How do the courts decide if you get bail? Default of the justice system is that you should be released on bail without conditions. Bail with conditions can only be applied if the prosecutor proves to the judge it is necessary. Article 515 of the Criminal Code, the latter principle, can be used to determine which conditions will be set. Under this principle, we start with the lowest step, which are the least strict conditions, and if necessary, work our way up to higher and stricter conditions. For each time we go up a step on the ladder, the prosecutor needs to clarify and justify. As a last resort in exceptional circumstances, cash by deposit can be a condition. Judges need to clearly show it is needed, and it should be reasonable according to Section 11 of the Charter of Rights and Freedom. Conditions are not punishments. Their purpose is to make sure you show up at trial. They are based on the restraint principle, which means conditions should be applied within your ability to follow them and only as harsh as the crime committed. In cases where the accused is indigenous, Gladue principles should be applied. These principles consider background and systemic factors relating to why you have committed the crime or what is preventing you from complying with your bail conditions. Under Article 515.10 of the Criminal Code, bail is allowed if you do not pose a flight risk, pose a danger to the public, or you can be released without compromising the public's trust in the system. Sureties is another way you can get bail. A surety is a friend or family member who agrees to supervise you when you're out on bail and will be responsible for paying a fine if you violate your bail conditions. Your surety might have to testify in court, and there are specific requirements about who can be a surety. Judges should exercise restraint and set the value of the surety at a price you can afford.